So I want to go ahead and welcome everyone. We will get started here. We have a few minutes. People will still be joining, but I wanted to say welcome. Thank you for attending. We're going to be exploring some issues around AI and how it impacts law and impacts our lives today. And I would like to go ahead and introduce our speaker. Professor Iria Giuffrida is a colleague of ours and is wonderful and is excited to share some knowledge with you. So I will turn it over to you.
Thank you very much, Amy. She kindly mentioned I'm Professor Iria Giuffrida. I am a professor of the practice of law at William & Mary Law School, and I'm also serving as an assistant dean of academic faculty affairs. Which is a very long name to say I'll do all the tasks nobody else wants to do. And I don't have much of a choice. What I wanted to say is, because we haven't started officially yet, at some point my colleague Amy King will start recording the presentation. So if you're uncomfortable with that, you're more than welcome to just close your, shut off your videos. You can both ask me questions during the presentation. I don't mind being interrupted, or you can simply type them in the chat. My colleague Melanie Forehand is also here, and she'll be monitoring the chat because I have I'm a child of the pandemic, so I've got multiple screens and I don't know how to use them. So you can type your questions there, or then I'll leave enough time at the end of the presentation to sort of discuss. Obviously, this is a short presentation, so there's only so much that I can cram in 40 minutes. So I would be very keen to hear what are some areas of interest of yours and how I can try to address them. Addressing my colleague Amy King. Amy, do you want to start recording the presentation?
I have turned it on, so we're good to go. Thank you.
Perfect. So let's start officially. I wanted to start with giving an idea of what we're going to be doing in the next 40 minutes or so. I'm going to try to give a little introduction on some of the AI technologies, with the big disclaimer that I am not a computer scientist. So this is an introduction from somebody who comes or looks at this kind of technologies from the outside. I know I can see at least one expert online, and so I will stand corrected, and it's okay to correct me if I say something that it's inaccurate. My explanation are going to be rather superficial. Well, what I'm going to do then is try to think about how AI technologies in general. I'm probably going to be focusing more on generative AI, and I'll explain in a moment what that is, and how they interact with the legal system. So I'm going to try to think about some of the benefits, in particular for the legal profession, some of the risks, both for the legal profession, but also more systemic risks. And because I'm a lawyer, I needed to find a way to shove some regulatory frameworks in the presentation. So at that point, you can check out if you want, but I'm very excited to talk, even if briefly, about the EU Act and what the United States has started to put forward in terms of regulation, both at federal level and at state level. And then I'll do what every speaker is always asked at the end of the presentation. I'm going to predict the future, which, as you can imagine, I'm going to do a poor job of, but I'm just going to give you some ideas of what are my predictions. You can write in the back of an envelope, and will be tested in time. So the very first question is, what is AI? Because over the last probably 10 years that we've heard the term occurring in more or less every context. Some contexts are very accurate descriptions of AI technologies or use of the terminology. In other contexts, it's just a very good computer that is producing materials sort of in a very deterministic way, which has definitely nothing to do with AI. So the general definition, if you wish, of AI, which dates back to the 50s, I'm going to spare you the whole history of the development of AI, is sort of the reality, a computer program, whether it's just software, then it's a different piece of work, but let's just say a computer program that is capable of mimicking some features that we consider unique to human beings. We know that that is not always the case. Problem solving, I mean, animals do problem solving in different ways, but it's the idea of a computer program that is capable of displaying and mimicking some cognitive functions like learning, problem solving, or decision making. And the idea of machine learning, which is something I'm going to show this next slide, where I put it sort of in a diagram, has been the type of AI system that has attracted the most attention over the last probably 5 to 8 years. Now, there are different definitions of AI. You probably have heard news reports of engineers. I think it was an engineer at IBM who essentially fell in love with a large language model and ended up saying that the large language model had a sense of itself. So it was a sentient model. Again, take it from somebody who is not a technologist. I don't think we're there in terms of AI. We don't have a generalist AI yet. Maybe we'll get there, maybe we won't. I cannot predict that part. But the systems that we are now interfacing with regularity are very sophisticated systems compared to the deterministic systems that we still obviously use, but they have never really displayed that element of capability. And the feature that attracted certainly me at the beginning in this line of work was machine learning models that were capable of essentially modifying themselves based on the input and output of data. And data is the big word and goes really hand in hand with AI systems. The AI systems are very hungry and they need an awful lot of data. So the explosion, if you wish, a commercial level of AI applications is linked by the explosion at commercial level of IoT devices. I probably have 3 or 4 devices just around me that are constantly collecting, corralling, processing, and sending my data across the globe as it is. And this vast amount of data that we produce, terabytes of data that we produce on a daily basis, become really the lifeline of a lot of the AI applications that we're seeing sort of springing left, right, and center. Now, there's all sorts of ways to categorize AI, and so I'm not for a second suggesting that this is comprehensive. But what I want to say is that AI, in my mind, and again, I'm happy to stand corrected, is more of an umbrella term. It's not one technology, but they are technologies. There are different forms. Some AI systems are said to be connectionist, some are said to be more symbolic, and I'm not going to go into the difference. But what I wanted to capture in this slide is the fact that there are different kinds of technologies that have been used for some time, have been refined for some time. The green circles are the ones that we're talking about, we've been talking about more recently. So machine learning, I include itself as sort of a bit of an umbrella term, is the type of AI system, as I explained, that is capable of statistically learn from the data to which it is exposed. Now, this learning process, I put in sort of air quotes, because it's not learning like we learn as human beings, but it is a process and means that the software, or the technology, is capable of changing the way it produces output based on the input that it receives or that it is exposed to. Now, a subcategory of machine learning is deep learning, and you might have seen some charts online explaining or trying to represent, this is a sort of a form of symbolic AI, trying to represent the way in which the brain, we think, works. And I need to emphasize the fact that we really don't understand very well how the brain works. But anyway, we know how neurons, so we try to predict how neurons are working in the brain structure, and they are connected and interact often with each other and with neurons in different levels. So deep learning tries to mimic this process of networks interacting with each other so that the data points sort of keep moving across the network. And the deeper the levels of the networks, the more complex is the way the data is processed, and the less comprehensible it is for us. I will be talking a few slides from now about the black box problem, which is born roughly in this space because it means that we are mathematically or sort of technologically unable to explain and predict with precision the output of every single time a system has an input and then generates an output. I remember talking years ago with a cryptographer So he made it very clear to say he was not a machine learning specialist, but we were trying to discuss how do we even represent, how do we explain this kind of concepts to people who are new to this industry. And the beautiful image that he's given me is that of a Martian, of a little ET. He said, we produce something that works in ways that is similar to how we think we work, or rather how we think our brain works, and yet it escapes our scientific method of predicting the result every single time. So we don't really know how it works. Of course, that is also into inverted commas, because computer scientists understand a lot more than I do, and yet they too are unable to specifically explain how a particular output is generated. Now, this will make a little bit more sense when we speak about generative AI, and we'll speak about, I'll mention a little bit hallucinations, especially in the legal context, and how these hallucinations are exactly the result of this particular process. Now, in the deep learning bubble, the generative AI, which is what we've been talking about since November 2022, is the little red dot at the bottom of the chart. So it's a very minute currently area of AI technologies, but it's the one that is attracting the most interest because of some of the features. First of all, because they've been made available for free online, but also because some of the features are really mind-blowing and mind-bending. Now, why question that often students ask me, so why do we need to worry about AI? And this is the very legal answer. There's any number of issues that AI systems and AI technologies are raising from a legal perspective. Intellectual property issues, going back to generative AI, think about the strike in Hollywood. Very rarely have we seen actors joining the picket lines, being concerned about their images now being used to generate synthetic version of themselves. So if in the past women actors were really concerned about the pressure of having to go through surgery to maintain a very youthful look, now they can just worry about something which is bigger, i.e. being completely unemployed, because once their youthful look is captured by the AI system, their eternal synthetic self can live in Hollywood and keep acting, and they can sort of decay in the background. Nobody's gonna really worry about them anymore. Of course, it's sort of meant in a simplistic fashion, but we have seen people worried about the ownership, the intellectual ownership of what is being used to train the systems. The author Grisham, but also King, have joined lawsuits against OpenAI saying, hang on, to train ChatGPT, you have used definitely my box. And how did they find out? It's because if you use ChatGPT, whether you use the 3.5 or the paying service, which is the 4.0, you can ask ChatGPT to draft a short story in the style of. Now, I'm sure that ChatGPT was also trained on my PhD, which probably would be the biggest use of my PhD in history, as nobody else would have looked at it. There's very little to say about writing a short story in my style, right? I don't have such a distinctive style. It was a very, very dry publication. But authors who make their living out of having really created a particular style of writing are feeling challenged, and I think rightly so, by the fact that a machine can generate in maybe 5 seconds something that is very similar to their work. And so these cases are making their way, and eventually they're going to land on the desk of the Supreme Court, where we're going to see what the Supreme Court says in terms of, is it a violation of copyright if books written by an author, which are protected by copyright, are used to train a model, and this model now has incorporated the spirit, if you wish, of that author. The same applies for generative AIs that produces images, so short clips of videos and so on and so forth. So that's the first intellectual property question. Is copyright, for that matter, also trademark, infringed if these systems are trained on this vast amount of data without first asking permission or paying a royalty to the owners of those respective, be it copyright or trademarks? There's more intellectual property questions at the other end. Who owns the output of AI systems? Just this morning, one of my wonderful students was presenting his paper in a class that I teach on sort of AI and the law, and he's focused on plagiarism. And the fact that, for instance, William and Mary, as I suspect in very many other institutions across the globe, plagiarism is the idea of taking somebody else's work and passing it as one's own. Well, AI is not a somebody else's, it's a something else. So is this a form of plagiarism? And in this moment, I can tell you the deans, assistant deans, provosts across the nation and beyond are scratching their heads trying to think about what do we do about it? Is this a form of plagiarism or not? And again, that all depends on how, from an intellectual property perspective, we treat the output of generative AI. There are all sorts of compliance issues because, as I said, AI systems are very hungry of data. And the question is, are the data that are fed to the systems being compliant with privacy laws? As we know, there are privacy laws at state level. There is not yet a federal privacy law in the US, except that a bill has been introduced recently, which was very surprising because very many attempts have been done in the past and none of them have yet been successful. But maybe this is the right time for legislation to proceed. I have to say, from what I've read and my prediction, we're not going to move terribly fast on a federal privacy legislation. For those of you who are not based in the US, you might have heard of the GDPR, which is a European regulation that deals with data, which actually does have an effect, extraterritorial effect in the US. Any US businesses that handles data from European residents has to abide by the European rules. So are these rules, so there be state, federal, or coming from other legal systems, being respected when the data is used to feed on or to feed these AI systems? And this also leads into risk management. Businesses don't like risk. They want to find ways to mitigate, if at all possible, eliminate risks. And so developing these AI systems, or even just using freely available AI systems like ChatGPT, may suddenly create risks of liability that had not necessarily been taken into account as businesses sort of create their business model and try to minimize and manage those risks. This leads to issues of, for instance, product liability. Again, another student of mine wrote a fantastic paper on thinking about whether chatbots that offer psychotherapy support, and that, as it has happened at least once in Belgium, recommend to somebody who's going through a mental crisis to actually kill themselves, and the person then follows on the advice and does kill themselves, who holds the liability? Which of the various actors? There was, of course, a healthcare provider that had recommended this particular tool. This tool, I've read some research that suggests, this is very early days, but that suggests that people suffering from certain form of mental distress find comfort in these tools. And so they are, in some parts of the world, provided as a form of support. Again, not the only way to treat mental health stress or conditions. But who is liable? Is it the healthcare provider, or is it the business that it's suppose a separate business that had generated the particular application, which was feeding off OpenAI, ChatGPT, large language model? So where does the liability sit? And the answer of the paper is, in this moment, we don't know, which again makes businesses very tricky in expanding in this area. This doesn't mean that businesses are not expanding, they are, but it does produce certain forms of anxiety. Again, going back to the issues of privacy, there are other sides of issues, which is that of data security. In the age of big data, if my data is treated in compliance, for instance, with HIPAA, which is the US statute that deals with healthcare data, my data is treated in compliance with healthcare data, but somehow is then poured into a bigger pool where other data of mine is also present. Can you truly anonymize the data? And the answer seems to be, from the scientific literature, that the true anonymization is becoming ever harder to actually maintain, precisely because different data pools are now being used to train the systems, allowing the sort of triangulation of data to then identify back who the original data point was. There are antitrust concerns when businesses use price maximization tools, which are there to make sure that they offer products and services at the price that consumers want to pay. Are these AI systems, most of them are based on machine learning, so not generative AI, but are these AI systems going to collude with each other? Because the AI system is trained to produce a particular kind of result. That result could be very easily achieved if all the prices in that specific market were fixed at a particular rate. This would give any antitrust authority in the world heartburn. So, but these are issues that are emerging and that have not yet been fully regulated. I'm not going to go through employment and healthcare, but you can see how these AI applications are likely to cause an awful lot of legal issues. But the reality is that as much as these issues are very real, they're very they are difficult to predict, and they're difficult to resolve and mitigate. People are worried because of this. And I would have loved to have been able to draw this particular vignette, but I haven't. But we're mostly worried that AI is going to take our jobs, which is part of the reason why lawyers are now really looking carefully into AI systems, which allows me the opportunity to sort of migrate into how my profession is thinking about AI applications. There are certainly benefits in AI solutions, especially when it comes to automating tasks that are very repetitive and that take an awful lot of time for human beings. I am I often say a recovering litigator. When I was in private practice in London, I often had to do what we call disclosure exercises. In US legal terminology, they're called discovery. Fundamentally, it means that parties to litigation have to share documents with each other, and documents is anything that can record some kind of data. So data and metadata have to be disclosed in the context of litigation. And so I spent a big chunk of my early career sitting in front of a computer and reading endless thousands upon thousands of documents to decide whether the documents were relevant to the dispute and therefore had to be disclosed, or where they were not, whether the documents contain legal advice and therefore, although they were in principle falling in the category of documents to be disclosed, I could hold them back because of a specific form of legal confidentiality, if you wish, that I could claim on those documents. So this process took, we were armies. In fact, as I became even more senior, I hired entire armies of junior lawyers who sat in front of the screen and did the same thankless task that I used to do. In hindsight, that thankless task taught me to read contracts extremely well, and so I'll talk about this in a second. But in the short term, it meant that the client was that clients were paying vast amount of money for this task that I was doing. And as much as I tried to be very efficient, like any other human being, I had peaks of efficiency in my day. I was then working generally 100 hours a week, so I wouldn't say that my mind was sharp at all times. So being able to automate some of these processes is going to have, and it's already happening, so it is already having an impact in terms of the quality of the work products. As machines will get tired, and so there is a predictability in terms of the output. Tasks can be automated, and therefore lawyers can be moved to more, perhaps more creative tasks. So lawyer can be positioned to review and overview what machines are doing. And so you're going to need fewer lawyers to do this kind of exercise, thus making, in theory, litigation cheaper. I haven't seen an awful lot of prices dropping, but the idea is by creating greater efficiencies and having these tools are sort of more widely available to firms of all sizes. I was working in what in the US what you would call big law. So it was a big law firm that had vast amount of resources, which other law firms may not necessarily, definitely don't have. But as these tools are sort of becoming more available and the prices for access to this tool is dropping, there is what's called the democratization of access to legal services, which in itself is a very, very important aspect. I remember jokingly saying when I was a lawyer in London, I would be charged out at about £450 per hour. Which I would like to make the conversion, but I don't know right now what the conversion rate is. It translates into expensive per hour. I was not paid £450 per hour. I need to make that very, very clear because people have different expectations, which meant that if I ever had a legal problem, I would not have been able to afford myself. So I was in a very good job. I was paid exceptionally well, considering the 99% of the British public, but I could not have afforded my own legal services. So having tools that allow greater access to sort of legal redress, for instance, means that people who in the past couldn't even consider about getting some legal advice now can. So there are some tools. I mean, I even start by thinking simply ChatGPT. I don't know if anybody has ever received a summons to appear in court, whether as a witness or as a juror. They are written in a language that Chaucer would be embarrassed to write. It's incredibly complex. It's got a lot of thou and Latin expression. So the ability for anybody receiving this kind of very imposing and intimidating legal documents to have them translated in plain English, it already has an enormous impact on how people relate to, for instance, courts. I know I work often with the National Center for State Court, which actually has a quarter next door to the law school in Williamsburg. And they are offering a lot of training to state judges just because that's their constituency. In terms of thinking about what other solutions could be developed to make access to justice more readily available to people who cannot afford legal services at all, let alone expensive legal services. So there are some courts that are developing chatbots to answer very simple procedural questions. For instance, where do I go and file my divorce petition? Or what does it mean to have to file a divorce petition? There are courts that are trying to create even more robot-like tools to interface with first-time comers to court to make the experience of being a court much less stressful and therefore more accessible. There are online tools, so some of them might have had some problems with the legal system. I'm going to mention that in a second, but there are online tools that, for instance, help people who have received a ticket to challenge the ticket and have perhaps the fine either reduced or even cancelled altogether. It is possible to draft a will online for, if any cost. In fact, there are some tools that offer it completely for free. So it perhaps is preferable to have a will, even if maybe not terribly sophisticated, than having no will at all. So the democratization of access to justice is possibly the single biggest contribution of these solutions and these tools to the life of or to the legal system in general. What it requires us lawyers, and this is what I think every law school is trying to do, but it requires us to train the next generation of lawyers with additional skills that we in this moment don't necessarily understand ourselves. So we're very lucky we have a substantial group of alums who are keen to collaborate with us to train this next generation of lawyers in both existing tools, but also have them work in conjunction with innovators so that they can together come up with solutions that may fill the gap in the legal market. Other kinds of solutions that exist and are being used, these are sort of big law solutions. They have created, I know, a number of the big law firms in the United States have created their own ChatGPT, and they're trained their own ChatGPT on their own documents, and therefore can get draft contracts relatively quickly put together based on the various precedents that they've used. In reality, the precedent bank existed when I was a lawyer. So I very rarely, and I don't think that very many lawyers in big law draft contract from scratch. We always start from a precedent, which then is adapted to whatever the needs are of the client. This process of adaptation is becoming shorter in time, and the work product that is generated is becoming better in terms of quality. So some lawyers fear that machines are going to get rid of us, citing the senior part of a law firm, of course, in this moment, of DLA Piper, to the question of whether machines will replace lawyers. The senior partners answered no. He said it's not machines that will replace lawyers, but lawyers who use machines are going to replace lawyers who don't. And that's what the new skill icon means on the slides. We have to equip the next generation with not only the ability, but also the open-mindedness of learning new skills, because this will be required for their careers. Now, what are some of the downsides of having this wealth of tools available for law firms and also non-lawyers facing some interaction with the legal system? From the lawyer perspective, what we're very worried about is a drop in competency, having lawyers not truly understanding what their job is about. And I can explain this in relation to, for instance, ChatGPT. What every law professor in, I think, certainly in the United States is worried about is the students will use ChatGPT to draft, whether it's their exams or papers. Papers have always been, it's sort of a team effort. I give feedback to my students, they come back with the next draft. And so there's a lot of interaction, me trying to help the students finding their own voice, but also following the kind of structure of what legal papers look like, in particular those that then get published in law reviews. But I know that my colleague, Laura Killinger, does the same kind of work for students that produce actual legal output, such as memoranda or contracts or the proper legal writing. So our fear is that if students delegate that task to a machine, they're going to lose the ability of a particular skill that is intrinsic in our profession, which is that of learning not just to write, but also to read legal documents. Now, some people say that this fear is perhaps misplaced because there are useful ways to use tools such as ChatGPT to actually improve one's writing. And again, my colleague Laura Killinger and I have been working with a couple of other colleagues from the main campus of William and Mary to create some kind of guidance for faculty who want to learn how to help their students using these tools. So it is possible to actually become a better writer by using these tools. This though requires, of course, self-awareness, requires effort, and requires efforts on our side. We cannot just get up and repeat the lectures we used to do in the past. We then need to be significantly more engaged, especially in what pertains how we assess students. I don't think my job as a lecturer changes, my job as a grader does significantly. There are a very serious issue of confidentialities. We're trying to bang into the head of every single law students that come through us, never, ever, ever put any client confidential information on ChatGPT. And in fact, it's not just client confidential information that they shouldn't put there, but also client information, even if general. Let me give you an example. If we have a student that ends up working in a law firm that is advising a client in an industry that is very concentrated, for instance, in an industry that deals with chemicals, and the chemicals that is the particular business is working with is a chemical that can be found only in 2 parts of the world. And there is a chemical that I know has this particular feature, which was a case that I worked on when I was a junior lawyer. So just in not putting the name of the client, where the client business is located, but even just putting the name of the chemical compound on ChatGPT flaws immediately the confidentiality obligation that we have to our clients. So it's not just confidential data that cannot be shared, also other data that may not be look confidential in its face, but that would allow the system to very easily, or somebody that can try to jailbreak the system, I'm going to explain that in a second, to very easily identify who the particular client was. Jailbreaking is one of the very many expressions that are developing sort of in the cyber/AI world, which suggest a technique of getting, or tricking, if you wish, the AI to reveal information that it has been trained not to reveal. So very early on, I think that, I cannot recall, I don't think it was ChatGPT, but one of the other large language models that have sort of hit the headline was tricked into revealing its source code. And I can promise you that no computer scientist would ever want its machine to reveal its source code. So these are techniques that are being developed. They become ever more sophisticated because, of course, computer scientists are trying to, and coders generally, trying to raise barriers around the information that AI systems shouldn't reveal. There are issues of privacy, and I don't want to repeat those because they remain the same. Other issues that are really not linked exclusively to the legal profession, but there are much broader issues of that of fairness and bias. AI systems, like any other piece of technology, is the product of humans, and therefore it carries our fingerprints, which means that they are biased. We look at the world through our lenses, and that's what we put in the systems that we produce. Now, bias has a positive and a negative term. There are, of course, negative connotations, but I would like my students to think about bias more as a neutral term that simply describes the fact that we are unable to truly predict every single possible implications of what we create. And however hard we try to create something neutral, we're still going to transpose to our artifact, if you wish, an element of what is our experience, of what is our objectives. Sometimes they're expressed and sometimes they're not. There is a fantastic article written in 1984 by in fact, I want to say it's a philosopher called Winter, if I'm not wrong, the title of which is "Do Artifacts Have Politics?" which is a very sophisticated way to say, do objects carry somebody's view? And the answer is, unsurprisingly, yes, they do have politics. The best example that is brought in the article is building bridges in the area of New Jersey that goes from New Jersey, sort of the urban area, to the beach. The bridges were intentionally built very low so that buses carrying the public that wasn't able to own a car, so the masses, if you wish, couldn't get to particular areas of the beach. This is a way in which a bridge, which sounds a pretty neutral thing, can actually be heavily politicized. And just like bridges, so AI, and even more so, these kind of technologies that are so difficult, and in fact, I'm going to the last point, we're not able to truly explain how they are made, how the output is weighted, and what factors are taken into account when a system produces an output. This in the legal world has become particularly contentious because there are certain systems like Compass that are used by judges to determine the either the level of bail or predict the recidivism of a convicted defendant. And having a system that predicts somebody's recidivism, which is based on, for instance, even just historical data, which we know is biased against particular minorities, means that some minorities may be more affected than others. Now, in particular, ProPublica did write a very damning article against Compass, alleging that it was racist. A professor from Duke, a computer science professor from Duke, conducted an independent analysis and concluded that, in fact, Compass is not biased in terms of race, it's biased in terms of age. Younger males would receive longer sentences and would have higher level of bail, if at all, versus older or much younger defendants. So the black box means that we don't know exactly how these things are, how information or how data is produced, but this data in the legal world has a significant impact. What I tell my students is that they don't want to be that ChatGPT lawyer. The very first ChatGPT lawyer, I mean, at least that we have known, is the lawyer in the Mata versus Avianca case, who is now sort of known across the globe, produced a brief through ChatGPT. What ChatGPT did in terms of ChatGPT worked the way it was supposed to be. It was supposed to work. Large language models are designed to produce an output that sounds plausible, not an output that is correct. Correctness is not the criterion that large language models use. Now, there's a lot of effort to try to make a lot of large language models also correct. But what the large language model does is to produce something that sounds plausible. So if I suspect a junior lawyer puts a query or a prompt, as they are correctly called, into ChatGPT, please can you write a brief in response, a brief from the other side? What ChatGPT will generate is something that sounds like a very good response to the brief. And if there are no cases that ChatGPT could find in sort of, if you wish, in the data that it was trained on, ChatGPT will actually make the cases up. And this is one instance of hallucination. So the lawyer in this very first case just received the lightest, I cannot even say a slap on the wrist. It was asked to pay $5,000, which I think it's ridiculous. In fact, the lawyer had lied on a couple of occasions about what the source of his information was, but we're going to gloss over. things started to get a little bit more serious in the cases that you see sort of listed down the slide. In one case, the lawyer was actually suspended. There were some sanctions. In the case of Michael Cohen, his motion was denied, not necessarily just because of ChatGPT. It might have been a whole context and also what the motion was really about. The one that I try to point to my students is the very last one, which is a case in which the lawyer must have given the task to a junior lawyer. The junior lawyer did not check the references. So the lawyer submitted a brief with hallucinated cases. And the Court of Appeals of Florida did not give the lawyer an easy time. Not only was she suspended for a year, she needs to go through ethics training, but more worryingly for lawyers, the lawyer's case was dismissed. So this means that now clients are paying for the failures of the lawyers. Now, lawyers do have insurance. The client can sue the lawyer for malpractice, as it should. But this is not a model that works well, right? We shouldn't rely on professional insurance to take or make good the harm that is suffered by clients. So what's sort of happening? We're seeing two big shifts, if you wish, or two big forces at play. There's a lot of scholars, and not just so practitioners, politicians, NGO organizations that are trying to work hard on governance, trying to create rules on how we think about the systems, how we use the systems. It's a form, if you wish, more of self-regulation, right? Creating internal rules and then following those rules. And then the second kind of answer is, well, we must regulate this kind of world. And this is what the EU has done with the EU AI Act. I'm looking at the time, so as much as I would love to go into details, I'm not going to do that. I'll just show this slide, which shows sort of the pyramid of how the EU legislators, plural, have thought about risks posed by AI. So it's a risk-based approach, which is very different from what the US proposed approach is going to be. And the EU considers certain kinds of risks unacceptable, for instance, social scoring using AI and various data pools to score individual citizens as to how deserving they are of particular services. This is an unacceptable use in the EU versus a system that for instance, creates smart traffic lights. There's no reason why they don't pose unacceptable risks. In some contexts, they may still have to be checked and sort of processes to ensure that they continue to work the way they're meant to have to be put in place, but they definitely should be allowed into the common use. The United States has taken a slightly different approach. It's a rights-based approach. This is still really not developed, so I don't want to suggest that we have legislation. A couple of years ago, the White House published a blueprint for an AI Bill of Rights. This is really the very first time that we hear AI and Bill of Rights in the same context. And in October 2023, President Biden signed the executive order on safe, secure, and trustworthy AI. This is a little bit more granular. It starts giving directions to federal agencies of certain things that they have to do, and thinking about governance of AI, having somebody responsible for AI systems, thinking about how to procure AI systems is becoming it's going to be a mandatory requirement for federal agencies. How you implement this mandate is going to be seen. And states are also regulating AI at state level, mostly in the context of privacy. So it's not really AI regulation per se, it's just, it's a byproduct of trying to regulate privacy. So looking at the future, I would like to have the crystal ball moment and tell you this is what's going to happen. These are three very basic conclusions that I hope are going to be non-controversial. The first one is that AI is here to stay. We're not going to see a disappearance of AI systems unless perhaps electricity is no longer something we can produce. So I think especially for my profession, which is notoriously a profession that really doesn't like change, we're going to have to adapt, and law schools are going to have to adapt. Because AI is built by humans, it's not going to work well. So there's going to be problems. And we need to think about, try to anticipate these problems and try to create systems that redress any harms that are caused by these systems. And what I tell my students is that we all need to be committed lifelong learners. We're going to need to try this. It's not a law school the end of their studies. They're going to have to continue to learn, whether they learn on the job, but the intellectual curiosity needs to be something that pushes them along the rest of their career. Now, at William and Mary, we're trying to do something along these lines for those that are no longer students or those who are sort of already in the profession. Amy King, my colleague Amy King, Melanie Forehand, both of them are online, and I are developing two different kind of programs. So we have a compliance risk management for innovative leaders. We're trying to provide leaders with awareness and tools to try to face some of these challenges. And in fall 2024, which means coming August, we're going to launch an online Master of Legal Studies, which is aimed at non-lawyers. We want to reach out to a vast section of the working population who is actually dealing with legal issues. Privacy is not just the domain of lawyers. Privacy is also dealt by accountants, by technologists, by sort of front client-facing positions. So we try to speak to those populations and tell them, come to us to give you an understanding of the tools that you need to do better your job. So we've got different concentrations. We start with risk management and compliance and financial law. We're going to them moving into healthcare, emerging technologies, and environment. I'm going to stop there so that I'm 5 minutes over time, so that I leave a little bit of time for questions, and I might also stop sharing my slides.
So thank you so much for that. That was, I know, a lot of information for 45 minutes to get in. So we appreciate how hard you tried to get all the information we need. As Professor sorry, tongue-tied, shared, she's ready for questions. We can also take questions in the comments and the chat if you prefer to have them there. Both Melanie and I are watching that space for questions. So if you have any, please go ahead and share.
And maybe what I'd be interested to hear from people on the call is, what are sort of some of their anxieties? What are some of the areas that perhaps professionally they would like to have support, but they don't have? I'm trying to think about my students are telling me, well, we don't know how to use ChatGPT. So we're trying to provide some support. What do people in other professions experience? What can be done to sort of bridge the gap between these new tools? They are coming at a pace. Every time I'm asked to do a presentation, half of the slides are out of date, so I have to update them. So the speed at which this technology is coming is making it very hard for us. Hi, Carl. How are you? Please ask your question. I think Carl, you're muted. Okay, there you go.
Yes. Okay. Yes. Thank you. Thank you very much for the interesting presentation. So here's my question has to do with the intersection between the issue of unauthorized practice of law and the various sorts of risks associated with AI. So on the face of it, it looks like there's as you said, there's the executive order. There's
I'll follow up on this side. Don't worry. Go ahead with your question.
Yeah. So, but I guess the question on the face of it, it looks like for unauthorized practice of law, there's sort of a positive and negative side of it. When there's a kind of negative side, which is a sort of a monopolistic thing, sort of restricting competition, and we can't really feel too great about that. On the other hand, another part of it is to limit people's exposure to bad advice. And so one could imagine that when you apply UPL to computer systems, that there's a sort of a similar, there could in principle be a similar issue. Like there's a question of of resistance to being losing your job because you're automated away. On the other hand, what we're seeing now is an explosion of bad advice that anybody can get just by asking ChatGPT or Claude or any of the other systems. And just conceptually, I wonder if you have any particular insights into the relationship between those two.
Carl, this is a fantastic question that would deserve in itself an entire presentation. What I can say is that there is an English scholar who calls himself a futurologist. I didn't know it was a job title you can apply to be a futurologist, Richard Susskind, who has been thinking about law and technology for a really long time, right? So this is not the first time that he's come to think about these issues. And the point that he makes is we seem to look only at the two extremes, right? On one hand, we are monopolists, very happy trying to keep our monopoly for ourselves, and therefore making it unaffordable for the vast majority of people to get legal advice. When my husband and I had our will drawn up, I was astounded by how much money we spent, which is probably more than the net worth of the two of us put together. We're still paying my husband's school debt. So on the other, we have the idea of sort of this unvetted legal advice available to everybody. It's mostly because this is where we're placed in this moment. What I think Professor Susskind and other along the lines of his way of thinking, they're thinking about ways in which we still can have good quality advice provided to people. So ChatGPT tells you on its face, I'm not here to give legal advice. Don't follow what I'm saying. Sometimes I get things wrong. People are using it because in this moment is the only thing that they can afford. So what Susskind and others are sort of proposing even is a pressure on the governments plural, so not just the United States, obviously, for them to develop solutions that are accessible and sort of a large language model that is not owned by big tech, but is owned by the government. Reality, this is going to be very, very difficult. The other thing that Professor Susskind talks about is more in the area of redress and thinks about solutions where AI tools could actually help a large number of very, very small claims. Many of us in the litigation world have been reading about ODR, online dispute resolution. And so this would be ADR in the sense of AI dispute resolution. Having AI tools so that can resolve those disputes that otherwise go unresolved or that would require one of the party to invest a vast amount of money that they don't have. So I think that what he and other scholars are looking at is that middle ground, where you still are going to have lawyers that have to provide the complex kind of legal advice, but there is a relatively broad spectrum of tasks that can be, with AI systems properly designed, actually fill a gap that currently exists. Where do I stand? Probably relatively close to Professor Susskind, although I'm not Susskind would be very happy to get rid of lawyers. And he makes a very good point. He says, the law is not there to keep lawyers employed. And that's true. Law is there to provide justice, to provide, redress, and to ensure that rights are protected. It's not there to make sure that my students, or I, for that matter, have a job. So he's suggesting rethinking about what law and what technology can do to provide what law is about, forgetting lawyers and judges who are very worried about the job.
Yes, thank you. Thank you very much.
Thank you.
We have a couple questions. I'm sorry. We have a couple questions in chat. One is, how will explainable AI mitigate the issues you raise in one of your first slides?
So explainable AI is still work in progress. To sort of bring everybody up to speed, computer scientists and coders, etc., are working on AI systems that can tell, for want of a better expression, how they got from point A to point B. So a lot of work is being invested in this moment, but we don't have yet explainable AI. Now, I want to draw a difference between explainable AI and maybe I talked about the black box, the transparent box, or the white box. If in this moment AI could tell me in AI speak how it reaches sort of how it draws from point A to point B, I still wouldn't understand it. So the idea of explainable AI is not only a technology that is able to decipher what has happened, but also to communicate it in a way that can be understood. I don't think we're there yet. It could mitigate some risks. I don't think explainable AI is going to be able to tell us with clarity. The reason why I reached this particular solution is because I've looked only at this particular data, which, as you know, is very biased in favor of or against something. So the nuances, even having an explanation, is not going to be sufficient in understanding the parts that are either implied or out of sight. So I think this is encouraging from one perspective, because it means that anybody still has to exercise their critical thinking to try to work out how you get those answers, or whether those answers are truly correct or are the answers that we need to follow. But that's sort of briefly my, well, not my current approach.
Great, thank you. Another question, any indication why the US is not interested in the EU risk assessment model going forward, instead opting for the AI Bill of Rights approach?
So I'm going to give you a cynical, the obvious answer is I don't know, right? I'm going to give you a cynical answer and a less cynical one. The cynical answer is that big tech has a big hold on legislators in this country, mostly because a lot of the big tech companies we're talking about are actually US businesses. And businesses across the globe perceive regulation as a cost, and it is a cost. It really is a cost. If you go back and look at the kind of literature or even news around the first half of 2018, when the GDPR was about to come into effect, it came into effect on the 25th of May. So if you read anything sort of that from May prior to the prior year, the businesses were terrified that they were going to go out of business, and some actually did go out of business. Some businesses, like the Wall Street Journal, decided not to do business in Europe because it was going to be too expensive for them to do so. So yes, regulation is a risk, and I think that big tech has been sufficiently influential on the US legislator. Now, I have to say that this doesn't mean that the big tech don't want any regulation at all. In fact, Microsoft and Amazon have been avid producers of draft legislation, and have put it in front of various members of Congress. But obviously, that has a particular self-interest in that approach. So that's why I think we are where we are. This is why again, this is my personal view, we don't have a federal privacy regulation. As to the difference between a risk-based and a rights-based approach, the risk-based has some limits, which means that it kind of sets a particular way of looking at how AI system works, which to some extent means that you need to have harm to be able to measure risk. And although this is certainly going to be a very good framework many times, in many circumstances, it may actually not be able to capture more nuanced and long-term harms on specific communities. So things that you cannot immediately consider a risk of materializing, or a harm that somebody or a community has experienced. So I like the idea of the rights-based approach, because your right remains what your right is, and it should remain across time and across different situations. So it promises to be a more fully embracing kind of protection. But what we've seen so far is still very, very early days, and I cannot tell you that I've seen an awful lot of this full-rounded degree of protection. But I want to give the US legislature an opportunity to sort of try to develop their own conception. I suspect that, as you imagine, elections are going to have an impact on the activities of Congress. So I don't think we're going to see anything much happening this time until November, and whatever the result of presidential elections is going to have inevitably an impact on how Congress is going to approach these issues in the next 4 years. So it's very difficult in this moment to predict how much this blueprint will be filled out.
Okay, great. Thank you. We have one more, and we probably have time for one more, might go a tiny bit over. What specific changes do you see law schools making to legal education to address the rise of AI? And given AI, what advice would you give to a current undergrad student who is aspiring law school students and lawyers?
So in terms of the first part of the question, I think, of course, I can speak more confidently about what we are doing. So I don't know what other schools are doing, but I suspect like us, they're trying to think about, first of all, in terms of large language models, how that is going to impact the skill set that these young lawyers are going to be expected to display when they enter the job market. Inevitably, we have a bias, a generational bias. We assume that every young lawyer is much more tech literate than older lawyers, which may be true, may not be true. I often tell the story that a few years ago, coming back from the pandemic, I told my students, I was actually teaching at the business school, so they were undergraduate students. I told them to bring the laptop to class because every class we were going to take a quiz. This is until a minority student approached me and said, "Professor, I don't have a laptop." So that bias which I displayed, and I wish the ground had opened and chewed me and spat me out at the other end, it's real, right? So I think it's important for law schools to take a very positive approach in trying to equip students with as much prowess as we can in this kind of tools. But I'm speaking only about large language models. I spoke 2 weeks ago with an alum who is actually a consultant in this space, and who is advising law firms on how to create efficiencies by using tools that don't necessarily give advice. This is how, for instance, you case manage litigation, or how you manage deals and things of the sort. And this kind of technology, I think we should tell students that this kind of technology exists, but we don't. And we don't for any number of reasons, including the fact that law schools are always a little bit disconnected from what is really happening in private practice. So that's what I think we should do better. As for students who are aspiring to go to law school, what I suspect we'll keep looking more for in the next generation of law students are critical skills. Being able to think creatively outside of the box, being able to respond to counter arguments, and showing a desire to keep doing so is going to be one of the strongest, I suspect, soft skills that we're going to want to find in the next generation of students. So are we going to look for coders? No, we've always had some law students that are technically minded, not necessarily. I don't think law firms are only going to look for coders/lawyers, but I think they're going to need people who are able to translate. I was just attending a meeting earlier on. We were speaking with 2 alums, in fact, from the business school, who were telling us the one thing the market needs are students that are able to translate. In that specific context, we're talking about cybersecurity, so able to translate the cybersecurity frameworks on assessing risk to what you gotta do to comply with the law, to what the risk is at business level. But you can use that approach also to law students. So we need to equip them with the ability to translate these technical risks, these very profound risks, even to, if you wish, to the structure of democracy, into actionable steps for either the law firms or their clients.
Okay, we've gone a few minutes over. So again, I want to thank Professor Giuffrida today for sharing her presentation and all the information with us. It's been wonderful. So everyone knows I will be emailing out the recording, so you have this for your reference in the future. And we thank everyone for joining us, taking some time this evening to talk about this topic with us. Hope you have a great night, and please reach out if you have any further questions. We'll be happy to address them. So thank you.
And thank you from me as well. Thank you very much.